Hey everyone, I'm going over today no contact orders that get put in place during a time when you're getting your bond set. And obviously, for some people, not having contact with their significant other can be very frustrating for a number of reasons. You may miss the person, you may have never spent any time, this much time apart from each other, and the alleged victim in the case may really want to talk to you, you being the defendant. So I get these questions from clients from time to time, and they want to know, even if the alleged victim is calling me, can I respond? If the person is texting me, calling me, emailing me, trying to get signals or messages to me through third parties, like I feel bad if I can't respond to her or to him. And the answer to that question is that if there is a no contact order in place, you absolutely, as the defendant, you are under an order, a court order. And it doesn't matter what the victim does, you are not allowed to respond. You're not allowed to get a message through someone else. If there is a flat out no contact order in place and there are no exceptions that the judge has given you, then you cannot respond to the calls, the emails, the texts, the instant messages, or whatever, however, through a third party. And you may think, well, we need to talk about child custody, or we need to figure out how we're going to get our taxes done, or how am I going to get my keys to my truck or my car or my business. And the best way to retrieve your belongings is to have a sheriff's deputy or some kind of law enforcement accompany you to the home. You do not want to disrupt the alleged victim's daily activities, and you do not want to keep going over to the residence of the victim or keep contacting the victim with a sheriff's deputy present. I mean, it needs to be like, get everything you need, possibly make a list of it before you go over there with the sheriff's deputy. Because sometimes, folks go over there and they start thinking about things that have to do with the case, and then they forget what they came over there for. And then they leave and they're like, I still don't have my razor or whatever it was they went over there to get. And I also think that it is a very valuable tool for people who are under a no contact order to keep a calendar or notebook or some kind of, I have like this little notebook that I use for stuff. And, you can use any kind of notebook or calendar. You can use the notes on your iPhone or whatever. But I think it's important to keep track of the times and the days and the frequency that the alleged victim has tried to contact you. And I'm not trying to get the victim in trouble, but let's say this is a case where the victim does not want to prosecute, and it's a domestic violence case, and we want to show the court that, look, this person contacted me all these times. I did not call the person back because I'm under a bond restriction order and I respect the court's order. But, she's called me all these times, or he's called me all these times. He obviously is not in fear of me. He obviously, wants to work things out and doesn't want to prosecute, or, maybe still wants to prosecute, but wants to talk about counseling or trying to get around some issues. You can print screenshots, you can print out emails. Documentation is something that, any written correspondence of text messages, those are things that you may want to keep for your lawyer. And your lawyer may not be interested in it. I mean, people who represent people in these types of cases, they handle them all different types of ways. But I personally would like to have that, a record of that. I'd rather have it and not need it than need it and not have it. So remember, no matter how many times this person who's the alleged victim calls you, contacts you, you do not respond. under any circumstances. No exceptions. You know, if you would like to try to get the bond modified, that is something that possibly your defense attorney can do for you by filing a motion with the court. And, you know, we may have a hearing in front of a judge, because typically the prosecutor doesn't, consent to this. The state would notify the victim. The state should notify the alleged victim. And then, so we don't have to, be involved with communicating with the victim. We want it to absolutely comply 100% with the court's order, and until that order is modified. And it may not be modified at a motion for bond modification hearing, but, at the bond modification hearing, the judge may say, well, you can have contact, but you need to first complete anger management that takes X amount of weeks. Then that's what you comply with. You do not violate a court order, because if you do, you could go to jail for contempt, but also it just messes up it could mess up your entire domestic violence case and defenses. And you should absolutely respect the privacy and whatever boundaries the victim or alleged victim sets with you. For more information on domestic violence cases, head on over to my website at www.swilliams-law.net. And remember, you are under a no contact order. The victim is not under a no contact order. So the victim does not get in trouble for calling you, but you absolutely could get in trouble for calling the victim or texting or communicating, whatever method of communication there is.